Hello, my name is Andrew Nyamayaro. I am a solicitor at Tanlo Solicitors, and I am here to make a presentation on an important topic, which is a topic of immigration. This is a series that we are starting that will be going on, and as solicitors, we will be discussing a number of topics. So the topics that I will be covering over the due course of period would cover immigration, employment, family, disputes, resolutions, wills, probate, and so forth. I am a solicitor at Tanlo Solicitors based in Coventry in the United Kingdom. But today I've got an important topic that I want us to discuss, a topic that touches a number of people. So the topic that we want to talk about is on immigration. And this topic was introduced by the Secretary of Home Department, or the Home Office Secretary, as people normally call her. And as you would know, the United Kingdom has been saying that there's a number of immigrants that has come into the UK. So for the reason that they say that there's been a number of people that have come to the UK, they have introduced what is called a white paper, and it is now common with a lot of people. That was introduced around the period of May 2025, the white paper. So, as part of the white paper, the Home Office has been introducing different rules, different requirements that we announced in the white paper in bits and pieces, in installments. And of late, in November, there was the latest one which they introduced. So, the one that they introduced in November 2025 is the one to do with settlement. Settlement is also known as indefinite leave to remain. So, if you are in the UK and you are on a pathway to get your settlement, you came in the United Kingdom on a skilled worker visa, it's commonly known by people as the COS, or you are here on human rights or asylum protection, which is called refugee. Um, any route that you came on, please, this information is important to you. And if you know anyone who is affected or is going to be affected, you can call them in, or you can at least link them up with this presentation, tag them so that they will be able to hear what I'm going to present on. And if anyone who is listening has got any questions, the contact details are on the screen, and you can also send your questions in the chat so that I will be able to respond to the chats as well, as much as I can. So, as I have said, the Home Office Secretary of State introduced the white paper, and part of the white paper that I am discussing today is to do with indefinite leave to remain. So, in the past, even until now, because the law has not yet changed, if someone got on a route of immigration, each route had its own way or a pathway towards settlement. So there is commonly two routes to settlement. The one is called the 5-year route and the 10-year route. The 5-year route is commonly used for people that have been in the UK legally, and they take 5 years to get to the settlement. I say 5 years or 10 years, but there's been other qualifications. Some would qualify at 3 years and so forth. Some would qualify at 6 years back in the day, but commonly it's 5 years and 10 years. So most people that are, say, on the skilled worker visa, people that are on um, student and other routes that are the points-based systems, and that are on family, such as a spouse or a partner, could qualify and can qualify for indefinite leave to remain or settlement after 5 years. However, some people would qualify for settlement after 10 years, particularly those who have been on human rights. Some of them would have overstayed their initial visa. Some never had a visa at all. And once they got their visa, then they would be put on a 10-year route, which meant that it would take 10 years for them to get to settlement. Off my head, people that were, say, for example, who became legal in the country as a result of having children in the UK or having spent 20 years in the UK under private life, then they would qualify under the 10-year route or on medical grounds or on discretionary grounds, as the Home Office would put it in. So those ones would qualify after 10 years. So it was a matter of accruing time and also a requirement of good character, which again is being changed by the Home Office. Someone would then get to a settlement. And once they got settlement, then immediately they would qualify for um, public funds. As we know, the issue of public funds is an issue that is ongoing for a while as well with people. And so they would qualify for public funds and they would qualify for other things that were not there. Sometimes they would be struggling to go to university or get student funding, etc. But with the settlement, then they would be able to have access. So the Home Office is proposed that going forward, after the consultations have been done, because at the moment we are in a period of consultations, and I encourage everyone who is affected, or the relatives of people affected, the employers of people affected, because this will apply and affect as well employers, to also take part in the consultations that are taking place. So the government is making consultations, but in a summary, because the document that I'm talking about has got nearly 80 pages, so I'm just going to summarize what is in the document. So they are saying that if it is implemented, then the baseline for settlement will move from 5 years to 10 years. So that will be the starting point for settlement. If you want to settle in the UK, the starting point will be 10 years. There will be some reasons why you can reduce the 10 years to as little as 3 years, or to extend the 10 years to as many years as 30 years, depending on your circumstances, depending on the route, and depending on factors that the Home Office has pointed out. So they are now calling it what is called end settlement. You have to earn your settlement. It's no longer automatic because you have spent so many years in the UK, then you automatically qualify. So they are saying that it's now going to be earned, and there are various reasons or considerations that they are taking into account on the issue of settlement. So the new baseline is 10 years now, and the factors that will increase or decrease it are the ones that I'm going to comment on in this presentation. So the first factor is the level of skill. So despite your level of skill, anyone would spend 5 years or 10 years and then get the indefinite leave to remain. But now they are saying that in terms of level of skill, they would want people that have got a level of skill of RQF level 6. That is a degree level to have the baseline of 10 years. So if you are on a route that has got a qualification of less than 10 years, for example, people that are on the care visa, people that are on the SOC code 6135, 6136, because of the level of skill in that visa, they are saying that it would be put at 15 years. And some of them will be at 10 years, but because of other vectors, then they can be increased or decreased. But for the level of skill, it is a consideration that is being taken into account. So that means that people that don't have a degree might take longer than 10 years to then get their visa of on settlement. Another point that the Home Office is also raising is a point of integration. So integration, it simply means that they want you to associate and take yourself as part of the community and integrate into the community, be part of the community. There are some people, when they come to the United Kingdom, they never integrate, or their integration is slow, or doesn't take place at all. You will find out that some people, after having been in the UK for, say, 10, 15 years, they cannot speak a word of English, or they struggle with the word of English. They have never worked, they've never done anything to the community, they've never paid back to the community, and so forth. So the Home Office is trying to discourage that and saying that people should integrate into the community and do things such as voluntary work, um, do associate with your neighbors in whatever way that is possible, give back to the community as such, which might be very difficult, especially for people that are on a skilled worker visa that are required to be working full time for, say, 37.5 hours or 40 hours, because they have got no recourse to public funds, and you don't have spare time to do other extra activities that you would normally want to do. So it's something that the Home Office is looking at, and maybe you might have to try to balance your work life and your integration into the community and give back to the community. If you go to a church, are you volunteering into the church? Are you volunteering into the community? What things are you doing there, and so forth? So those are some of the things that are there. They are looking at under integration. Another important factor that the Home Office is looking at is what is suitability or a good character. And for those that have got access to the document, what I'm commenting on is mainly you need to read mainly page 21, page 22, and page 23 of the document. You can get it online. It's entitled "A Fairer Pathway to Settlement," and it is available online. A fairer pathway to settlement. That's the document that I'm talking about. So, suitability, good character. That is an important point that the Home Office is looking at, because they say that if someone comes to the United Kingdom, that should behave. In other words, they should not engage in criminal activity. They should not have a criminal history, and they should have a clean file, so to say. But we know that offenses are by commission and omission. You might not necessarily end up with a criminal offense because you are, strictly speaking, a criminal. You might end up maybe with a criminal record simply because you of a RTA, road traffic accident, or a road offense and things like that. You've just gone through a traffic light, etc. So some of those things do happen, but they will impact on your roadway or pathway to indefinite leave to remain. So we need to be very careful about what we do in terms of criminal activity. And also some of the things that I've noticed in the community, things like domestic violence, husbands or wives or partners fighting, abuse of children, and so forth. And even if it's a petty crime and you do it repetitively, that will affect your record as well. So we need to be very careful. Good character criminality is something that the Home Office is looking at. And if you've got a criminal record with the new requirements that have been put out by the Home Office, it might even be very difficult, if not impossible, for yourself to get to the stage of getting indefinite leave to remain. Citizenship, to become a British citizen, will just be a dream for yourself. Another thing that has been pointed out in the document is debt. They don't want people that have got debts to get indefinite leave to remain. But it's not yet spelled out what do they mean by debt. There's good debt and then there's good bad debt. And if I, for example, am a skilled worker and I've got a mortgage, that's a debt. If I'm a skilled worker and I get a car on finance, that's a debt. Is it going to affect my um, pathway to settlement? Or they are talking about people that have got a criminal, a bad file, your credit scoring is affected, you've got CCJs against you, and so forth. So I think it's the latter that they are referring to, but again, we are yet to see the details of that. So that's suitability and good character. Something else that will also affect your pathway to settlement is if you have accessed public funds. We know, for example, that people that are on a skilled worker visa, you've got no recourse to public funds. Some people that are on human rights grounds as well, you've got no access to public funds. And you can make an application if you are on a human rights visa to apply for recourse to public funds. We just did another application that was successful in the past few days, adding recourse to public funds because of the change of circumstance of the client. So do not access public funds if you do not have the recourse to them. The records are kept by all the departments, the DWP, the HMRC, and so forth. These departments tend to communicate to each other. So if you have accessed public funds for more than 12 months, then it will affect your pathway as well to settlement. I think it will increase it to more than 15 years because of that reason, off my head. But it will definitely increase the baseline from 10 years to a longer period because you've accessed public funds. Non-compliance with immigration rules as well. So if you came illegally, if you are not complying, if you've got bail conditions and you're not complying with the bail conditions, if you didn't pay your IHS or you used the NHS when you were not supposed to use the NHS services, that might, and you didn't pay for the services, if you're supposed to pay for the NHS services, that will also affect you. People that have entered into the UK illegally, especially those that are entering by boats, yeah, are the worst affected, in the sense that it will take them up to 30 years before they can get indefinite leave to remain or a settlement. And they are also affected in the sense that even for those that came before the law changed, they're also affected when it comes to citizenship. We deal with cases for people that came on routes that are not legal and that are trying to get citizenship, and the Home Office is currently refusing that, and we are in the process of challenging the Home Office. So illegal entry also affects your pathway to indefinite leave to remain. Again, the Home Office will be looking at your contributions to the exchequer, that is your contributions to the economy. If you are not contributing anything, then you are likely to take longer if you are contributing more. And that's why they also have made it easier for people that are highly skilled, like people on the innovator visa, people on the global talent, and people that have got resources. They can get their settlement with as little as 3 years because they can subtract 7 years. So I've got the document here. It says contribution applicant who earns a taxable income, for example, of 125,140 for 3 years, might minus 7 years. So they'll get their indefinite leave to remain after 3 years, and because of the high contribution that they are doing, and also highly skilled people can also get it less. People that work in the public sector would get their indefinite leave to remain at 5 years. So if you are working in the public sector, you will get your indefinite leave to remain after 5 years. And also there's things to do with English. So the factors are integration, contribution, entry, and residence. Then there's also things to do with English, life in the UK, which also is going to be made harder for people. At the moment, they look at B1 and then B2, but they want to put it at C1, which is higher than what it is at the moment. And at the moment, for most routes, it was just applicable, especially when it comes to extension to the sponsored employee. But going forward, the proposal is that even the adult dependents have to do the English test. So those people that avoided doing the English test, you need to consider reading for the English test, because it might be something that will be implemented by the Home Office as well. So those are the major factors that will affect your pathway to settlement. But especially for the people that came on the carer visa, that is a major concern, because they constitute the highest number of the people that came from the period of 2020 up to the present, after Boris Johnson allowed people for low skill to come to the United Kingdom. And if every one of them is going to go through, it's likely that the people that will get settlement is going to increase by quite a large number, um, because people came in large volumes. The anticipation was that maybe they would come alone, but they then came with their families to such an extent that the numbers, someone would have sponsored their partner and two, three, four, even five children, and so forth. And that is the aim of the Home Office, to try to stop people from getting indefinite leave to remain, which us as practitioners, we believe that that is unfair. And not only unfair, I think that should be called unlawful. I understand that there is different organizations that are challenging this proposal by the Home Office. There's a group of academics, there's a group of practitioners, and I encourage everyone who is affected, employees and employers alike, members of the community and society, to petition the government, to speak to your members of parliament, to complete the consultation that is going on. There is an online form that is available that people can sign, or people can complete, so that their voices can also be heard. So the next question would be, if I am affected, what should I do? Should I just fold my hands and remain quiet? It is important that as an affected person, you take action, just like I have said, to also have your voice be heard. And for those people that already qualify for settlement, or for those people that already qualify for citizenship, I encourage you to do that straight away. So apply for your citizenship, apply for your settlement before things get harder, because whichever government it is, whether it's going to be the Labour, the Conservatives, the Reform, the Liberals, there is this political pressure that is there at the moment to make immigration, or the desire for immigrants to come to the UK, more difficult. And that was why we are having all these changes being implemented by the government. So if you qualify now, then you need to take action. The important thing also to bear in mind is that, as for children, the government has made a positive change. It's now, for example, fee waiver is now available to the children if they cannot uh, afford it for their citizenship. The periods that they are looking at are now less. It's now less stringent for the children and so forth. But it's no longer automatic for a parent to just rely on the child to say that I can get papers on the child because the child has spent 5 years, 7 years in the UK, then I'll get it there. You have to put now detailed evidence and information to prove that. As a person who is affected, it's also important to upskill yourself. So if, for example, you are a carer, you can do the NVQs, you can upgrade yourself, NVQ 345. If you can do that, speak to your employers, do whatever you can. In terms of your 20 hours, if you can and your circumstances are allowed, do something that might be different from the care work if you're able to do so. I know for a fact that some people came on the care visa, but they are skilled in other specialities. There are some people that came on the care visa who, for argument's sake, might be lawyers, accountants, teachers, uh, and different specialities that they have. And if you can then use your 20 hours to get voluntary work, to skill yourself, to write your exam, to do your conversions, etc. That might be something that might be important, and for the English as well, because the English test, by when most people will qualify, it will be at the C1 level. You also need to be involved in the community. If you can do things like voluntary work. You can volunteer in your church, in your mosque, in your temple. You can volunteer in the community. You can go to a food bank and volunteer there. You can start and run a charity, join any charity organization, and all those factors will help you to prove that you've integrated into the community. You can be a school governor. That's something that you can do. Why not become a school governor at your children's school, become a magistrate. You don't have to become to be a lawyer to be a magistrate, for example. There's a lot of things that people can do to volunteer, and if you do that integration into the community, you will take off 1 year to the 10 years or to the 15 years and so forth. And then the contributions that you do also will minus the years that you have to take on your end settlement. So those are the points that I wanted to raise in terms of the settlement proposals that has been proposed by the government. So I will just try to look through the comments to see if there is any questions, and I'll also check on my WhatsApp if there is any comments as well. But there is nothing there which I can see. Um, Either in questions. But if you have got any questions, and you don't want to say ask us publicly, please you can see our contact details on the screen. You can phone our offices. We are open Monday to Friday, 9 a.m. to 5 p.m. There's a WhatsApp number that you can send us WhatsApp or you can send us email. We have got a Facebook page, Tanlo Solicitors. We have got a YouTube channel. Also, just look for Tanlo Solicitors, and we will be present on Zimbo Live because we have got a partnership with Zimbo Live to do presentations and write articles on legal matters that affect the community, especially the diaspora community. Thank you so much, everyone, for tuning in. I will be again seeing you sometime next week. We will be live on Zimbo Live every Tuesday at 7 o'clock p.m. in the evening. So if you've got any topics that you want us to discuss, any topics of interest to you, just contact me and then we can have a conversation on that. We don't just do immigration, we do immigration, family, civil disputes, wills. We also do probate. If you've got someone that have passed away, and we can help you with managing their estate. If you want to write a will, you've got properties in Zimbabwe and in the United Kingdom and other investments elsewhere. You've got children, etc. We can help you to do your wills and so forth. Thank you so much. My name is Andrew Nyamayaro, and meet you again next week.